Well, welcome everyone to Emerging Topics in Blockchain Law. This is a webinar put on by GBBC's International Journal of Blockchain Law, also known as IJBL. For those that are not familiar with IJBL, it is an open access online journal written and edited by lawyers and designed to help business and non-legal communities better understand the world of blockchain and digital assets. So, as a reminder, throughout this webinar, we do have a Q&A box below. So if you have any questions, please submit them there. But joining us today, we have Stephen Palley and Preston Byrne from Rudnick. We have Eric Hess from Hess Legal Counsel, Laura Douglas from Clifford Chance, Kelly Chapman from Wave Digital Assets. And then I will turn it over to Matthias Arts, who is the editor-in-chief of the IJBL.
Hello, warm welcome from my end too. With this panel, both the GBBC and the IJBL have refreshed and chessed up this format with our new branding, Emerging Topics in Blockchain Law, where we will be covering pressing legal issues around blockchain and digital assets in all relevant jurisdictions. We will have panels on a quarterly basis going forward, and where possible, we want to create a link between articles written for the IJBL and individual panel topics. With that, I would like to hand over to Eric to introduce the topics and get started.
All right, so welcome everybody. Glad you're tuning in. Excited about this panel discussion today. We're covering, we're starting off with Preston Byrne's article, most recent article in the International Journal of Blockchain Law, where he talked about the distinctions between the UK and the US regulatory regime. And then in the second part of the panel, we're going to explore how these impact things like investment advisory in the UK and the distinctions with the US and how it all links to risk management generally. So with that said, Preston, do you want to kind of give us a brief historical overview of the regulatory approaches of the UK and the US towards digital assets?
Yeah, sure.
Let me actually put a pin on that too. We spent a lot of time going back and forth when you were writing this on your use of the word securitarian, which I hated and you pushed on. Talk a little bit about that too, how that choice of nomenclature informs your analysis and your understanding of that relationship.
Securitarian is the correct nomenclature, dude. I'll just say that. So anyway, good morning, everybody. My name is Preston Byrne. I'm a solicitor in England and Wales, and I'm also an attorney in the United States. It's a long story, but I am American, as you can tell, but I kind of did my law admissions backwards. I took a wrong turn off 95 one time and then wound up in Scotland. And so then decided to become a lawyer over there and then had to come back home and do it all over again. So with that said, back in 2013 is when I started to get into crypto. Bitcoin, started writing about it, blogging about it. And 2014, I actually left. I was with Norton Rose in London, left the firm and went to go start one of the first enterprise blockchain startups. And so when Steve asked me to write this article for the IJBL, it was interesting because it's a fun opportunity to look back to the past and remember all the meetups that you went to. And then you think about the guys who you know who are under investigation by the SEC and the ones who aren't. And it's an interesting distinction. And generally speaking, the guys who sold and marketed tokens in the United States during the 2017-2022 period are the ones who caught regulatory flack, and the guys who are in the UK didn't. And it's an interesting. There's an interesting story there. So the story is, if you go back to 2014, that was really the origin of the ICO, right? So in 2013, you had altcoins and things that were made, but they weren't really sold in the manner that we understand an ICO to be. The first sort of prototypical ICO was, I think, the Mastercoin sale. That didn't really, it was an interesting project by David Johnston. It didn't really get the kind of traction or attention it needed to really set off a market craze. Ethereum then did their token sale in 2014 in August, and then they launched the token in 2015. And even that wasn't the token sale that launched 1,000 ships, right? Because at the time it was a modest token sale, $20 million. People weren't making tons of money. What then happened was in 2016, 17, Ethereum started to rip, and everybody suddenly understood that this was a way that you could start making money. So we started to see this explosion of ICOs. And what followed, that explosion of ICOs was two very different regulatory paths. So, and we can see that really most distinctly in the treatment of cryptocurrency exchanges under existing, previous and now current UK regulations that have just entered into force in October. Long story short, the UK lets crypto be crypto. They permit spot exchanges to exist and trade spot crypto, much as spot crypto has been traded all over the world for the last 10 years. Whereas the United States is now bringing enforcement actions against the exchanges and is really trying to shoehorn crypto into a regime that exists for securities. And so I wrote this article as I referred to what America is doing as a securitarian trap. And so what does securitarian mean? Well, I started with securitization, and Palley didn't like that because he said that all the securitization lawyers would get their feathers all ruffled if I used the term securitization, which has a dual meaning, both the process of taking assets and creating fixed income securities out of them, which we all know and love. And then there's also this meaning, which is a more academic meaning, which means the subsuming of some type of economic or social activity under a security regime or security-focused legal regime for national security purposes. So you could refer to the Patriot Act, for example, as the securitization of banking, right? Because of various amendments to the banking regulations that took place there. So we had to pick a new word. So we picked securitarian, which means unduly or inordinately focused on security, and it has a dual meaning, right? The meaning on the one hand is it's concerned with security. You see Elizabeth Warren going on TV telling us that if Bitcoin is allowed to be traded spot, everyone is going to die. And then also a sort of tongue-in-cheek meaning, which is that they're trying to treat all securities everywhere as investment securities under the Securities Act 1933, which really isn't the appropriate regime. So that's the background. That's kind of how I approach this issue.
Great. And then shifting over to the distinctions between the UK and the US regulatory framework. Do you want to talk about the recent regulatory changes in the UK, particularly around? Yep.
Yeah, no, very, very happy to. And I think it's an interesting contrast with what Preston's just been talking about in the US. In the UK, I mean, we had back in 2019, the FCA put out some guidance on crypto assets, basically setting out its stall on the alternative sort of approach and interpretation, if you like, where it said actually most cryptocurrencies are generally unregulated in the EU, in the UK today. Or they certainly were back then. And actually, you sort of needed to do a substantive case-by-case analysis of the features of any kind of crypto asset to look at, does it really look like a debt security or an equity but that test has been applied, I think, much more narrowly based on a UK statutory definition, as opposed to the very broad approach that we've seen perhaps in the US around sort of whether crypto assets are securities or not. So the UK has definitely taken, FCA much kind of narrower definition as to what types of crypto assets fall within the existing types of, regulated financial instruments today. What we've sort of seen since then is a gradual introduction of a regulatory regime. So kind of the first thing that we saw was application of money laundering regulation to crypto asset businesses. And so that was based on the international FATF recommendations. The FCA did apply a very high bar to those registrations for money laundering purposes, but that was, linked to, do you have the right AML controls, etc. And linked to that, we've also seen introduction of the travel rule for registered crypto asset businesses here in the UK. But that's really relevant to firms that that actually operate sort of physically in the UK, generally speaking. From a cross-border perspective, and this is the development Preston mentioned sort of came in earlier this autumn, is around the UK financial promotions regime. And so this is really the first bit of the kind of financial services regulatory framework that really has been extended to crypto assets. And it's a key bit of how the UK is sort of trying to then, draw its perimeter and actually focus on, things like consumer protection. By ensuring that effectively, if you want to make financial promotions, so market or make other kinds of communications around investing, trading, etc., in crypto assets, including unregulated or otherwise unregulated crypto assets, then you either have to be already authorized and regulated in the UK, benefit from a particular sort of exemption or exclusion, or potentially get your financial promotion approved by someone who is regulated in the UK. That's sort of a very high level, and there are carve-outs from that general sort of restriction for things like wholesale kind of professional investment kind of business. So if you're at the wholesale end of the regime, it's a little bit easier in the way there are ways that international business can happen in relation to crypto assets, but particularly on the retail side, it's that crypto asset financial promotion restriction that is sort of currently the main kind of protection, if you like, that the UK has in place to ensure that regulated firms are behaving properly with respect to particularly marketing of crypto asset activities to retail.
And so following up on that, what would be like what are the implications of the differences in that approach between the UK and the US? Preston, do you want to talk about how that compares to the securitarian framework?
Yeah, so I think getting down to brass tacks, like what are the actual mechanics of the differences between the two systems? The United States uses a common law test called the Howey test from SEC versus W.J. Howey Company. Orange, it's the Orange Grove case. Everybody knows it. Not going to rehash it. Whereas the UK has a different approach where they define, or for the longest time, they defined securities by reference to a list and a definition of what is a transferable security, right? And so transferable security is a long list of things, debts, bonds, whatever, shares. But on that was not, blockchain system tokens that, are from blockchains that were hashed in a Genesis block. So for the longest time, the FCA didn't really have crypto within its perimeter because definitionally, crypto wasn't under the statutory power that they were given to regulate. So as Laura said, the first steps that they took were to bring most crypto asset, or what we would call a VASP business, the general, term that everyone's using, a VASP business, under the money laundering regulations, which is kind of like a quasi FCA authorization, not quite, right? It doesn't actually authorize you to engage in a regulated activity, but it is the kind of stuff and compliance that you'd have to comply with if you were engaged in a regulated activity. And the closest analog to that is what we would see like a 50-state MTL in the United States, the exercise that something like a Strike or a Coinbase or a Gemini would have to go through. And then what we have is we have the treatment of crypto itself, right, as not a security. Okay, that's great. So we know now in the UK, you can have these spot exchanges. They're regulated under the money laundering regulations. So you got to get KYC'd before you use it. But we haven't quite elevated the token to a status of a full-blown security. But what they have done is they've said, listen, if you're going to engage in the course of business in the United Kingdom, in the marketing or sale of these tokens, we want to make sure that those communications that you're making are authorized and that the manner of the communications that you're making is authorized by the statute, because we're not going to tell people, as Gary Gensler does, that you can't invest in this stuff, which is essentially if you're saying to people, listen, you're not allowed to buy it unless these companies go through this convoluted, Reg D process and list the tokens through an ATS or a national securities exchange, which supports crypto tokens, of which there are precisely 0 in the United States. So the US is basically prohibiting crypto by saying, well, it falls within this regulatory regime. And oh, by the way, the regulatory regime we have doesn't work with crypto because you're not allowed to self-custody your own assets, and no transfer agents exist who are able to perform this function, except again for perhaps the exception of INX. So the key difference is, I'd say it's a two-step kind of analysis, if we want to call it that. First step is, what is the thing and why? And the UK says crypto is not a security because it's not on the list of transferable securities. The US says crypto is a security because Howey says, anything that fits this loose common law test we have will constitute a security. Next step is, okay, what's the appropriate regulatory regime? UK said, well, we've got the money laundering regime. We can also, if you want, and you're an exchange, you can go get a full-blown FCA authorization or an e-money authorization to go and provide various types of payment services within the country. And that's going to work just fine. Crypto can still be crypto within that regime. Whereas the United States has said, well, we're going to have to re-intermediate transfer agents, broker dealers, and custodians if you want to interact with crypto. In other words, stuff that crypto is just never going to do, right? So the US is kind of living in fairyland where literally the entire rest of the world is saying, okay, we're going to set up regimes that allow crypto to do whatever crypto is, meant to do, and allow people to interact with it in the manner it was meant to be interacted with. However, we're going to impose some additional safeguards if someone is engaged in the course of business, which involves selling or marketing these crypto assets to consumers.
And are there any other countries in the world that are sort of going down the same path of looking at financial promotions or similar to what the UK has implemented, or potentially, and if not, even maybe looking at the UK and starting to contemplate the application of similar rules?
I think the European Union is being a little more progressive with MiCA. And so in that regime, I'm not overly familiar with it because I'm not a European lawyer, so I'm not going to dig myself into a hole and pretend that I know what I'm talking about. We have excellent referral partners for that. But I think the European Union generally and the UK know, right, that the golden goose is out competing the United States. And there's a very weird regulatory mishmash between the two countries right now, where the US is very liberal on applications that involve publishing, right? And this includes crypto asset applications that support publishing. For example, Library, which got taken down by the SEC, is going to be regulated as a publisher and isn't as draconian on data protection issues as the European Union is. And then the European Union and the UK are actually quite aggressive with the control of publishing, defamation, hosting defamatory content, hosting unlawful content, hate speech, that sort of stuff. But then they're quite progressive on all the financial applications of crypto. On the other hand, so on the one hand, the US has the First Amendment and then this draconian financial regulatory regime. And then the Europeans don't have the First Amendment. So they like to control what gets said on the internet. But then they're liberalizing their financial services regime to accommodate cryptos. It's a very bizarre split where, depending on what type of technology is the subject, and the same with AI actually, which is similar analysis. The US is going very liberal. The the EU is going down the road of regulating very heavily. So we have this weird divergence between the two jurisdictions, and I think the answer, the explanation at least, is that the only one of them has the global reserve currency, which is threatened by crypto, and that would be the United States, which might explain why we're cracking down on it harder than we crack down on other types of technologies. So that's how I'm reading the current situation. I think it's a moving target, and we're going to see a lot of variation over the next couple of years.
Yeah, agreed. And I think, there are various other jurisdictions in the world that we've seen, going down a variety of paths, but, moving towards a licensing regime, if you like, for crypto activities. And the general trend seems to be, I think we saw some early movers try and look at regulating crypto a bit more like payment services. I think we're now seeing a bit more of a sophisticated approach where perhaps it's recognized that it's not really a one size fits all. And actually, MiCA in particular regulates crypto, or will regulate crypto once it starts to apply, much more in the sort of the spirit of financial services, more like securities regulation, but then with appropriate links into the kind of the payment services piece, particularly for things like stable coins that are going to be regulated as, say, e-money, which is, an EU specific concept. I don't think you have the same sort of regulatory concept today in the US. So I think that, the regulatory regimes are becoming, I think, a bit more sophisticated to deal with different kinds of, use cases for crypto, whether that's sort of an investment or actually used for payments. And actually, just to pick up on MiCA and sort of the financial promotion question, MiCA sort of goes straight in with kind of the local licensing requirement rather than trying to sort of draw the perimeter while the UK is still developing its crypto asset activity licensing regime. But what MiCA does say effectively is that it kind of has a reverse solicitation provision in there, so that if you're not, if you're not an EU firm, but you want to, provide services to EU customers, generally speaking, that there's a provision that basically says, well, maybe with certain exemptions, like for intragroup, the only real basis for that would be reverse solicitation. So we kind of see something that probably has a similar effect to, the kind of the financial promotion restriction there.
And when you're talking to clients today or projects that are looking to locate in a jurisdiction, with the financial promotions framework, has that dissuaded people or slowed down the movement into the UK, or are most people saying, well, it's certainly better than the alternative in the US, and still embracing it and saying at least it's some clarity?
Yeah, so I think, I mean, it's interesting because the financial promotion restrictions really bite on non-UK firms, because if you're still in the UK, you should be regulated or at least registered under the money laundering regulations, in which case you kind of have a carve out from the primary restriction under the FinProm rules. So actually we saw the FCA doing a lot of kind of awareness raising about the new financial promotion restrictions, and put out some fairly kind of robust statements around the time that the rules were coming into force. And sort of it's put out a list of firms that it has identified as still were still kind of marketing into the UK as in breach of the rules. So in a sense, I think it's almost been that some firms maybe kind of were not quite ready for the restriction to come into force. And so we've seen the FCA take quite a reasonably robust approach, let's say, sort of to sort of making clear that, there is supposed to be a change in behavior at this point. For other firms, I think, certainly the clients and so on that we're talking to, then it becomes about strategy, and particularly thinking ahead that there will be a UK license, like a full licensing regime introduced in due course. So if you want to do business and if you want to, actually be able to market in the UK, do you find someone to approve your financial promotions? There are some firms around that may do that, but maybe not many at this stage. You're going to need a special sort of regulatory permission to approve financial promotions as of early next year. And then the alternative, of course, is then potentially to set up an establishment in the UK, get registered under the MLRs, and then the hope is that there may be sort of a route to to authorization once the full regime is developed. So I think those are the conversations we had with clients, seen people thinking about with the UK. And to be honest, similar with the EU, a lot of firms looking at their EU strategy, where should they set up to try and sort of transition into the MiCA regime as smoothly as possible.
Yeah, what I'd add to that is that, at least from the American perspective, being incorporated in the United States at this point, but for the fact that you have to raise capital from Silicon Valley VCs who like to invest in Delaware C Corps, which may change soon. I don't, given how aggressive the US has been, being a US operation is a black mark. So essentially, you have new entrepreneurs who are looking to enter the space, or existing entrepreneurs who are currently in it, got started up maybe in mid 2021 or 22, and then now they're looking for some kind of exit. Not exit in terms of financial exit, but exit from the United States and go do business in a jurisdiction where their business actually makes sense. So people are trying to minimize U.S. Well, they're trying. A lot of my clients are trying to minimize their U.S.
What do you mean black mark though? I don't quite follow that. Black mark for whom, or with respect to what?
That good question. I think when I say black mark, I think it's something where the U.S. is now viewed as a business risk, whereas before, any U.S. touch point was not regarded as a business risk. So when there's an opportunity to not use the United States, we're getting a lot of inbound where the initial query is, well, listen, I'm American. I live in San Francisco. My business partners live in LA. But we're going to incorporate in Cayman instead of incorporating in Delaware because we're so afraid of the United States that we don't even want to have a C Corp, which is incorporated in the United States, even though, right, depending on what you're doing, that may or may not be a relevant fact. So people are trying to take every possible effort, if possible, to avoid the US. And that sometimes involves looking at the UK as an alternative destination, or if you are a US company with an existing UK operation, looking to maybe scale up in the UK and in favor of the UK rather than the US. So the US is perceived as being very crypto unfriendly. We have to remember that crypto regulation is a moving target, and everybody knows that. So as a result, they look to somewhere like the EU or the UK, and they say, okay, well, I can set up business here, and I know that in 5 years, chances are pretty good I'm not going to have a couple of shrill New England senators, passing, with not naming names, Elizabeth Warren, so, passing legislation which makes my operating my business a felony. If I open it up in the United Kingdom. And so what's happening is jobs and investment and tax revenue are leaving the United States and going to those other places because people are making the bet that the UK is going to be friendlier for them in 3 or 4 years than the US is. That could change, I think, depending on the outcome of the 2024 election, on which I offer zero opinions of any consequence. Just saying, depending on which candidate you support, one candidate may be more crypto friendly than the other. At the moment, Biden's pretty crypto unfriendly, and Trump wasn't exactly crypto friendly when he was in charge. So I'm not terribly optimistic either way. But who knows? Who knows? A year's a long time. So.
Yeah, and certainly, when you have clients that are all based in the U.S. and they want to address some of that risk by just simply incorporating another jurisdiction, that just isn't even enough anymore. Like, if it doesn't involve starting to measure out the size of your suitcase for an extended residency, or taking up shop somewhere else, or hiring in another jurisdiction, it's generally not going to fly. Like it needs to be much more. Like I think earlier in the arc of crypto, there were companies that would just incorporate in Cayman and say, hey, we're a Cayman company. And then the SEC came in and said, no, you're completely controlled from the US and everything happens in the US. And you're just holding this sign up and saying, hey, we're in Cayman. And that doesn't cut it. So it often involves much more structural changes to actually exit the United States or to minimize those touch points to the US.
What I'll say is, just sorry to jump in, on a sort of final point there, it does depend on what your crypto application actually.
100%.
So if the crypto application is concerned with, so for example, a lot of the DSO decentralized social applications like DSO or library, or, there was like friend.tech, I think it was called. So if you're starting a social media company and it's got a crypto backbone, absolutely do it from the United States, because there is no power on earth. Basically, in order for the European Union or the United Kingdom to prevent you and your users from exercising First Amendment rights, the only thing that they could do it is land troops on US soil and occupy whatever state your businesses and your servers are headquartered in, because no US court is going to enforce a foreign speech code. So like, that's a crypto business that you absolutely do want to be founding in the United States, because the comparative regulatory advantage is enormous. By contrast, if you're going to start a derivatives exchange, then definitely, the worst place in the world to operate that from or get customers from would be Washington, D.C. by Union Station across the street.
Unless you want to register.
Unless you want to register and do all the rest of it.
Or find an exemption.
Yeah, in which case, there are these helpful people called lawyers who can help you do that. But that's, yeah. So what I'd say is it depends on the app. For most financial apps, you're going to have to obviously run the analysis. For a social app, presumably there's a financial component that you'll have to get some assistance with structuring. So if you're going to have a token which drives the application, it's probably not a good idea post-library to start distributing those tokens to Americans. But if you're hosting content, right, and maybe let's say the Americans who are accessing the service are going to do it via a server, whereas the rest of the world can do it via IPFS or something like that, it makes a ton of sense to operate that business out of the United States.
Excellent point. So we're going to start to look at how the consumer protective provisions, both in the US and the UK, can sometimes limit the ability of intermediaries, regulated intermediaries, to engage, and also the important role that, like, an investment advisor, for example, could play, in that, investment advisors can both function in the context of advising on investment, but also potentially, particularly the more sophisticated ones, address some of the tail risks that are associated with digital assets. Namely, we've all seen the headlines. Pig butchering is a very popular word. It's kind of very visceral, right? Pig butchering, scams, generally, rug pulls, and and certainly cybersecurity attacks, and even the risk of asset seizures, and all these things can sort of impact an individual investor's ability to engage in the market and their potential exposures and tail risk exposures. So with that said, Kelly, do you want to just sort of frame, the role of the investment advisors for individual investors, and how the current regulatory structure in the U.S. facilitates or does not particularly facilitate an individual's willingness to engage in sort of both managing their investments and the tail risks?
Yeah, sure. So I guess starting out, I will make the distinction that there are some investment advisors who are registered with the SEC or a state, or are otherwise, view themselves as regulated by those jurisdictions, because they either think that crypto is a security, or they're, sort of trying to do the best they can to comply while we live with this, uncertainty. So when I'm talking about investment advisors, I'm talking about those folks, right? Rather than others that sort of, they call themselves an investment advisor, but they're not really seeking to comply with the traditional investment advisory rules. So, investment advisors are fiduciaries. I think I would maybe just start with that. So when you're talking about things like tail risk and, a fairly volatile industry, lots of big wins, lots of big losses, potentially higher risk of loss due to fraud, hacks, bankruptcies, I think investment advisors are able to play sort of a really special role in terms of, of course, they have a financial incentive to help you do well with your, investments, but they also have that fiduciary overlay. So, I think that leads in general to the positive sides of, investment advisors can help you vet deals, do basic diligence. And, if it's too good to be true, an investment advisor will help you figure that out, because they'll know the market, they'll know the product, kind of easily see through those scams in a different way than folks might if they don't have that background. Understanding counterparty risk and kind of inherent risk of cyber risk, hacks, fraud, bankruptcy risk, right? That was something that was kind of a huge, led to a lot of large losses in the last year. Taking on things like diversification, hedging derivatives, looking at somebody's portfolio holistically and looking at their risk tolerance, all of those things that I think are really beneficial to folks that want to be participating in this space. But so, kind of getting back to the big picture, there is so much regulatory uncertainty. Folks have called it regulation by enforcement. It is a risky place to be acting as an investment advisor. As Preston noted, right, there's a lack of counterparties, a lack of service providers that play kind of very specific roles that are required. So qualified custodians, things like that really limit the way that you are able to provide services, those very needed, useful services to help protect your clients, frankly, and help them, meet their goals. And it's, in the US, and I think it may be the same in the UK, but I'd be curious to hear, there is a higher burden when you're dealing with what we would call retail investors, right? So folks that are not accredited investors or, institutional investors, but kind of your more everyday folks. And that has led, in general, and especially in crypto, to investment advisors not really wanting to play in that sandbox, right? Because there's not only that higher regulatory burden, but there's a perceived higher risk of, enforcement, right? If the SEC is coming after you and you've been dealing with folks that, Congress views as less capable of protecting their own interests, there's perhaps a higher likelihood that you might get in trouble for all of that. So, I think that investment advisors could be playing an even better role of helping mitigate a lot of these issues. But frankly, the kind of the risk of getting involved in general in the US and getting involved with more kind of retail broad-based folks is just too high for a lot of folks. And that is also another reason why I think there are people taking the position that these are not securities. And that means I'm just not going to pay attention to any of that at all. That's also a separate type of risk, but it's difficult there.
Yeah,
Um,
and just
yep.
Oh, sorry, I was just going to jump in to say, yeah, I mean, I think to your question, Kelly, I think, you know, that there's the same sort of higher standards or kind of higher levels of protection for retail in the UK as well. I mean, that's certainly true for traditional kind of investment advice on regulated financial instruments. And the UK is going to be introducing a similar licensing regime for crypto asset specific advice in due course. Where we are at the moment, I think, is just to go back to the financial promotion regime, that if you're kind of, you know, an investment advisor, you know, talking to clients about crypto asset investments, that's where you would trigger the regime. And particularly sort of on the retail side, you know, there are quite strict new rules around sort of crypto as a high risk investment, including things like actually for new customers, there's a 24-hour cooling off period before you're actually then allowed to trade.
Oh, wow.
So, you know, there's that period between customers saying, I want to do this, you know, as a new customer, you've got to give them all of these risk warnings, and then they've got to go away and sort of sleep on it before they can actually invest, which is quite interesting.
Another interesting wrinkle of the new UK regime is that there isn't a carve out for what we in the US would refer to as accredited investors. So in the United States, if you're Daddy Warbucks, you can go and buy, you know, whatever crypto you want as long as it's sold pursuant to Reg D because you're an accredited investor. And the government thinks, therefore, that you've got the credentials to be trusted on how you spend your money. Whereas little mom and pop investor on the street, can't be trusted, with anything or any discretion and judgment, and so they have to be locked out of those capital markets. The UK, on the other hand, has said, listen, crypto doesn't matter if you're making inducements to invest. Those inducements to invest, I don't care who they're to, or we don't care who they're to. They need to be approved by an FCA approved entity. I could be wrong, but I'm pretty sure that's what they say. So, in a sense. In a sense, it's stricter than the US, but it also kind of accepts that retail exists, whereas the United States says, listen, retail isn't going to exist. The current retail investor pathways that we have, that we have, chiefly Reg CF and Reg A, you're not really seeing a whole lot of issuances via those pathways because of the aforementioned problems with the US market structure not really making sense for cryptocurrency as a technology. So that's an interesting wrinkle and a difference between the two jurisdictions.
Yeah, of course, if you buy via Reg D, now it's basically an exempt security, and good luck trying to sell it. You still have to, so you're very limited in what you can do. So Daddy Warbucks can do it, but what's really the incentive unless you're really hoping for a change in regime or change in regulatory framework that that permits you to engage in it. So it's kind of like you're allowed to do it, but it's kind of a hope and a wish, right? That things change. And so, like, one of the impacts of all this is it puts the retail investor. It's actually harder to represent a retail investor than to engage with a retail investor, and the end result is that the retail investors are sort of left on their own more. Each regulatory regime sort of has that, almost encourages that. Like in the US, it's almost like we don't want to give it the credibility of having a disclosure regime that actually makes sense, which is a different topic than investment advisory, or even being more accepting of the role of the investment advisors in sort of mitigating some of the tail risks that concern a lot of people. In the context of the UK, Laura, do you want to sort of like comment on that? Because I think you were making some interesting points before on it.
Yeah, so I think there's an element of that, happening in the UK today as well, in the sense that, there's an existing cohort of individual investors, retail investors in crypto out there today.
We got a little bit of a freeze here, so we're gonna like pick up and sort of move ahead.
Sorry. Sorry. Am I back?
Yes.
Sorry about that. Yeah, the internet is causing some problems. But effectively, sorry, I was going to say that where we are in the UK is that, you know, we have the financial promotion restriction, which sort of is acting as a barrier, I guess, or a safeguard against, you know, new financial promotions marketing, particularly to, you know, potential retail investors, which actually means that it's the regulated firms that can potentially market and can potentially provide their services, whether that's investment advisory, brokerage, or others, you know, within the financial promotions regime. And therefore, actually, you know, there is an element of regulated firms being the best place to do that to some extent. I think, though, that there is still that, you know, concern that, you know, the higher kind of risk and regulatory burden for retail does mean that probably, you know, there are firms out there who are maybe more reluctant to go into the retail space than anything else. And actually, just sort of as an aside on that point, one of the things that the FCA, the UK regulator, has done already is to ban sales of crypto derivatives and crypto sort of related structured products to retail. So although retail can invest directly in crypto, they can't invest in financial instruments that reference crypto, which again, you might say, actually, you can see some potentially perverse consequences of that, because actually directly holding crypto comes with its own risks, as opposed to, you know, holding a product that gives you a one-to-one exposure to the value of crypto. But that's where we are in the UK, at least at the moment. You know, I think we'll see whether that kind of changes or is nuanced as the regime develops.
And Kelly, you're the general counsel of Wave Digital Assets. It's a investment advisor, registered investment advisor. How do you balance the provision of these risk management services, which do provide a service, with the regulatory burdens that are associated with providing services in the digital asset space?
That is a really good and very difficult question, because I am also Chief Compliance Officer. So I hope one day we will have enough of a team where we can kind of separate those roles. But right now it's, you know, I'm looking after both the business and the compliance needs. It's really hard. I mean, the way that Wave has looked at it, right, is trying to take the position that we don't know what is a security. We think that a lot of the things we're working with probably aren't, but until we have, you know, more clarity, until we have more certainty, we're going to try to comply with all of the SEC's rules, you know, within our control, right? So there are going to be things that investment advisors just literally can't comply with if they're investing in certain strategies. And so, you know, I think that's sort of the approach that the whole market is taking, from my understanding, when you are in this space, is, you know, good faith efforts to comply with the rules and just building on additional risk management, right? So if you're not, for example, there are some folks, you know, working in the DeFi space, and they may not be able to find a qualified custodian that is, you know, working within DeFi. So coming up with your own internal controls that sort of approximate the rule that you know you're not able to comply with, I think is one way that some folks are kind of looking at that. But I will also say, as you guys mentioned, folks are looking offshore, whether, you know, buying or moving offshore entirely, moving certain strategies that are harder from a US perspective, offshore, not accepting US clients, right? That's another unfortunate thing that I think is really happening, of sort of saying, look, based on the you know, totality of the risk, we really need to start focusing on offshore clients, you know, offshore markets, offshore clients. And, you know, it's very stressful. And I think that you see a lot of situations where there are opportunities where you could be providing value to your clients, not just from a risk mitigation, you know, perspective, but from the perspective of, I think investment advisors play a really special role in creating new financial products, right? Creative things that, you know, can really help move the industry forward. And doing it in like a, you know, regulated way, but a lot of those strategies, you just sort of say, we just can't do that right now. We can't do it in the US. Maybe we can do it somewhere else. So it's definitely difficult.
Yeah, and I think we were talking about some of the knock-on effects of the lack of expertise reaching impacted participants, and even some knock-on effects you wouldn't even think about, like, for example, government and law enforcement expertise. Kelly, you want to talk a little bit about that and your experience with that?
Yeah, sure. I mean, so I think if you kind of take a step back, I do think that you could, not to always knock on the regulatory lack of clarity as the issue here, but I think that if you kind of start with that and say this has led to a proliferation of actors that are not necessarily following the rules or don't know which rules they're supposed to be following, it's led to, the potential for a much harder time for law enforcement and government agencies to understand what's happening, to get their hands on what's happening. And then you add sort of this additional layer of crypto and the technology, underlying it, blockchain, being relatively new, right, to the mainstream, especially. You end up having varying levels of expertise at different, federal agencies, different states. So the IRS Criminal Investigation Unit is sort of like the preeminent, crypto knowledge holders, experts, basically, in the US, which is a lot of people are surprised to hear that, but they just have an incredible expertise, and they're trying to, they help a lot around the country as much as they can, but they can't be everywhere, right? And they need resources to help more. And so you end up having just a very wide variety of levels of expertise federally and on the state level. And that can kind of have those blowback effects of, maybe bad actors are not being caught and brought to justice in general because of a lack of knowledge of, how to find them, how to identify them, how to go after them. To the extent they are identified, varying levels of success in seizing assets or finding those assets. And then to the extent those assets are captured, right, it's possible that there are, the lack of being able to kind of optimally manage those assets while they're awaiting adjudication, that can lead to losses for, victims and the government as well. And so I think what we're seeing is just, we need more knowledge, we need more expertise. And I think the cool thing that comes out of that is there's been a lot of public-private partnership within the space because of that. So I think the most notable example is the, private track and trace firms that are just pivotal to the US in kind of bringing down criminals, seizing assets, helping get the assets back to the victims. But it's also happening just on a smaller scale of knowledge sharing between private companies, nonprofits, government agencies are really having to come together. The ones that believe in crypto and aren't just kind of burying their head in the sand and pretending it's going to go away if you just, hope hard enough, coming together to sort of say, let's work together. Maybe normally we wouldn't be at the table together, but because we have this common interest, we're going to come together on that. But, it's not the probably optimal way to be doing it.
And so, also that lack of expertise can potentially impact recovery from the asset seizures and the ability for victims to receive restitution. What have you seen in regards to that? And
yeah, I mean, I think kind of one of the things that I mentioned is sort of, even if you've seized the assets, they're sort of just sitting there, right? And there's a lot of things that government agencies could be doing to help, create yield or otherwise just better manage those assets. There's risk of loss, right, that we talked about earlier. If you're just sitting on assets, you don't know where they're being custodied or if that's a safe place or how to move them, appropriately or in a safe kind of way. And, I think in general too, right, it's just sort of, you have to have this level of expertise trying to, track and trace the assets, and getting them through that way. And I guess one other thing I would just mention, I don't know if this is something anyone else can speak to on the video, but privacy tokens are just another kind of big issue where I can see both sides of why you might not want to, once you seize those, release them back into the market. But it's a huge amount of potential returns back to victims that are, as of now, sort of just sitting just sitting because no one is willing to do anything with them, and no one has made a decision about what to do. And it's really, again, I think there's good arguments on both sides, but that's just one example of what do you do, right?
Yeah, I mean, it's interesting because like take something like, oh heck, just because I like the name, the bonk token, which is now worth like has this ridiculous market cap. It's not an unusual problem for the government to recover assets that have some sort of, I'm not saying bonk is illegal or unlawful, so let's use something else. If you have a token that has an uncertain lawful status, or maybe is used for unlawful purposes, that's not something the government is unaccustomed to doing. I think the question is, you have to be able to distinguish it. Instead of saying, yeah, this is like heroin, you're going to burn it, you have to say, no, there's actually a lawful purpose for this privacy coin, and there's a market for it. And as opposed to heroin, where you're hurting traffickers, maybe if you burn it, with this coin that you think is problematic, you're actually hurting consumer, you're hurting retail if you burn it. And part of the problem there is like, who are you having the conversation with and who's going to listen? Because one of the things that caught my ear is you said something about, productive or fruitful conversations with regulators. And I have, plenty of friends who are regulators in the United States, or not plenty, but some, or people I know professionally who are lovely, thoughtful people, but I'm not sure, I haven't personally found those conversations to be, that I've had for clients to be, they've been nice, but I don't think clients have felt that they've always been incredibly productive.
Mhm.
Are you
No.
finding, like, are there particular regulators you're finding are easier to engage with, maybe on the sanctions side with OFAC?
So I haven't, fortunately, and have not dealt with OFAC as of yet. I mean, we work and kind of talk to the IRS, right, about different
That's
things, but US Marshals, and but I would say really on the state level is I think we're seeing people that are you kind of get folks that get it, right, at the state level, and they have to be very self-motivated, but they want to do something about it. The downside to that, right, it's like, great, you want to chat with them, they want to figure out how to do this. There's a lag in the federal clarity, so let's make our own rules in the state level, let's make our state the place to go for crypto. But then you end up with 50 different states with 50 different crypto regimes. And so it's heartening to see folks stepping up like that and being more open to conversations, understanding things, education. But it's not the long-term solution unless the federal system just adopts, whatever great state comes up with something that's practical and workable.
Right.
One very brief aside, one fun thing you can do with privacy coins as a lawyer is you can determine which ones are the real deal by reading the charging documents, because there will always be something like, and the agent seized X number of Bitcoin, Y number of Ether, and an unknown quantity of Monero. So that's a fun, so you can always tell which ones are well built by reading the charging documents and seeing what law enforcement couldn't find out. So fun trip.
That's pretty funny, Preston.
And I mean, I think with regards to the asset seizures, and I just want to kind of develop on one point, which is it's not only the federal government that are seizing these assets. These are state agencies, these are state law enforcement agencies, et cetera, and their expertise.
Agencies, right? Yeah,
and there are overlays sometimes with civil litigation, and so it gets very, very complicated. I just worked on a matter where there was you had state and federal law enforcement, state court, federal court, civil litigation, criminal, and they're complicated issues too. Like one of the things that you see in the boom bust dynamic is like something was worth a lot, and then people decided to fight. Then it was worth not very much, and then nobody cared. Suddenly it's worth a lot again. So you've got like competing claims to the same asset between different parts of our federal system, private litigants, and complications over valuation. It makes for great business for lawyers. I will say that.
Right. But like, even like the states, when they're trying to pull on the expertise of the federal government, because they may not have the internal expertise. And again, as you think about these large pools of assets that may sit with, agencies that just don't have the expertise, there's a risk of dissipation of assets, and the advisory services, the investment advisors, could actually play a significant role in helping bridge some of that lack of knowledge. They certainly need help.
Yeah.
And the federal government is, it may or may not be able to. I think, Kelly, you mentioned that if you're enlisting the federal government as a state agency, you might have to pay 20% VIG, to get their to get their assistance. So, I mean, these are real concerns. It's not like they have the necessary expertise to go and access the markets, and they certainly have a lot of reservations, and there's a lot of confusion, and they may be sitting on large parts of money with some real significant concerns like that a lot of other actors in the space have. It's like, hey, we don't want to break any laws. We have all these assets. What do we do with them? How do we get restitutions for the victims?
Exactly. So that also just leads to longer waiting periods too, right? It's unfortunate all around. But I agree. I mean, I think that's one thing that we would like to do, and I would be, it would be great to see other investment advisors trying to help kind of fill in that gap. Especially as sort of mentioned earlier, you have that fiduciary duty. So I feel like a win-win in terms of helping obtain that expertise. The team of experts, we have some highly skilled technical experts that understand, the different layers of all of this. But again, you can't be everywhere. They can't be everywhere, right? So,
and so before we break, because we're running on time, or if there's any questions, I don't know, but maybe we can just get a view of this from across the pond. Laura, what do you, what is the overall approach and impact of asset seizures, et cetera, expertise in the UK?
Yeah, so I think, we've seen a few initial cases where, the courts have been relatively willing to try and, be helpful, in very sort of non-technical terms. And, to give an example, and this is sort of from, a year or two ago now, but the tulip trading case, where actually and this kind of links to the in principle question of whether crypto assets are property, and so whether therefore you can get kind of proprietary remedies in the English courts, and as I say, the courts have generally been quite sort of helpful so far, as far as sort of we've seen. I think one of the practical takeaways, which I think is echoing what Kelly's been saying, is that being able to trace your crypto assets very quickly to know where they are has been invaluable in the successful cases that we've seen. And also the involvement of some kind of intermediary. So whether that's a crypto exchange or, some other kind of intermediary, in being able to actually say, look, we know where the crypto assets are, they're in this wallet, and we've been able to trace them from, victim's wallet. This is, the path they've taken. And in those cases, it's much easier for a court to say, yes, okay, we can make an order to, freezing order or whatever it might be, and actually sort of, have a successful outcome. I think it's much harder where you don't have those sort of two factors in place. So, I don't know what that means. Probably there's sort of risk management implications for people investing in crypto there, but I think it's just a reality of the cases that we've seen so far, being able to sort of point to and trace the assets. And as you say, if you can't do that, or if the evidence isn't really readily available, then you have that question, what do you do? There may be willingness to try and resolve the issue, but yeah, challenging in practice.
Yeah, so I don't know if we have any questions or time for any questions. I'll let Riley chime in if we do, but assuming that we don't, I think we're at an hour. I hope everybody has enjoyed this session, and looking forward to doing more of them, and not losing my voice at the end. But thanks so much, everybody. Appreciate the time, and I think this was a great conversation.
Thanks, Eric.
Thank you.
Thanks,
Eric.
folks. Bye.
Thanks a lot.
Bye.
Bye.